Welcome back to the Deep Dive. Today, we're trying to cut through some really dense stuff, one of the most confusing, high-stakes areas of U.S. policy. This complex web of rights, responsibilities, and, well, financial obligations tied directly to immigration status. Yeah, this deep dive is really for you, the learner who needs to get the fine print right. We're pulling from legal reports, advocacy guides, policy manuals, the actual sources. And the rules here, often counterintuitive. Sometimes they even seem to contradict each other, but they're always critical. So our mission today is clarity. We need to figure out exactly who gets what benefits, what labor rights exist, even if you don't have permanent status. And this is a big one, what major, often global financial obligations kick in just by having a green card. It's a maze. Okay, let's try and unpack this.
Okay, so starting out, if we're charting that map, we really have to begin with the foundation, the law that sort of dictates who's generally excluded from federal help. That's the Personal Responsibility and Work Opportunity Act of 1996, PR-FORA for short.
PR-WORA. That sounds pretty heavy. What was the thinking behind it? Was it just about limiting federal spending, or, was the idea more to tie assistance directly to citizenship and work?
Well, it was a bit of both, definitely, but heavily weighted toward tying access to specific legal status, and cutting costs was a big part of it. PR-WORA basically says, broadly, that immigrants without what's called qualified status are ineligible for most federal public benefits. So this means if you're undocumented, you're generally excluded from those big means-tested programs, the assistance where you have to prove low income.
Means-tested. Like food stamps.
Exactly. We're talking about SNAP-P, which is print stamps. Also, Supplemental Security Income, SSI, for the aged and disabled. TAN, Temporary Assistance for Needy Families. And, this one's critical, subsidies under the Affordable Care Act for health insurance.
Ah, okay. So big gaps there. But looking through the policy manuals, it seems like the exclusion isn't absolute. There are some, mandatory safety net exceptions.
Yeah.
Things focus purely on keeping people alive and safe.
That's right. Yeah, the exceptions are narrow, but they're absolutely vital. They ensure access to emergency care.
Emergency care meaning?
Hospital emergency rooms. That's guaranteed by MMTALA, the Emergency Medical Treatment and Labor Act, and also emergency Medicaid, which, importantly, only covers the cost of those specific emergency services, nothing routine.
Okay. So immediate life-saving stuff. What else? We saw some things about kids.
Right. Beyond immediate medical crises, there's access in areas concerning children's well-being. Undocumented kids have the right to K-12 public education. That's a big one. Plyler v. Doe established that. And they can also participate in programs like Head Start and WIC, the Special Supplemental Nutrition Program for Women, Infants, and Children.
The WIC, right.
Yep.
Food support for moms and babies.
Yeah. These exceptions are critical. I mean, they basically prevent a wider public health or education crisis.
Okay, so that's the baseline for undocumented individuals. Now, let's move sort of up the legal ladder. People who have lawful permanent resident status, LPRs, green card holders. Even they don't just walk in and get full benefits immediately, right? There's this hurdle.
Exactly. They face what's commonly called the 5-year bar.
The 5-year bar. Why? Why the wait? Does that mean if an LPR gets here and, say, immediately has a disabling accident, they just can't get SSI or Medicaid for 5 years, 60 months?
That's essentially what the federal law says for those specific means-tested benefits. Yeah. The historical argument, behind the bar was this idea that new immigrants shouldn't immediately rely on public funds. They should use their own resources or rely on their sponsors during those first few years.
Can that wait be shortened? Is there any way around it?
Sometimes. It can sometimes be bypassed through work history.
Work history, how does that work?
If the LPR or maybe their spouse or even their parents, if the LPR came as a dependent child, can show they've accumulated 40 quarters of work credits.
40 quarters. That's 10 years, right?
10 years of work, yeah. 10 years of paying into the system through payroll taxes. If they can show that, they can often bypass that 5-year federal waiting period for those specific benefits.
Okay, that makes a bit more sense. It sounds like a kind of fairness mechanism. Like if you've paid into Social Security and Medicare for a decade, you're treated as having earned access, even if you only got the green card more recently.
That's precisely the idea behind the 40-quarter rule. It connects access to proven financial contribution to the system.
Okay, so this federal bar, this 5-year wait, it seems like that's exactly why states step in sometimes. They see these gaps creating hardship.
Exactly.
We noted, I think, 26 states offer some kind of state-funded program. And this is where state policy can get really interesting.
Yeah.
Let's look at California's program, CAPI, Cash Assistance Program for Immigrants.
Yes, API. It's a really vital gap filler in California. It offers cash assistance specifically for low-income seniors, 65 plus, and disabled immigrants who meet all the federal income and resource rules for SSI.
So they still have to be really poor, basically.
Absolutely. They have to prove they're truly indigent, meet those strict federal SSI limits, like less than, I think it's around $840 a month income for one person currently. Very limited assets.
Less than $2,000 in property, usually, not counting your house or car?
Correct. Those stringent federal requirements for income and resources still apply. The key is they are excluded from federal SSI only because of their immigration status or because they're still in that 5-year bar period.
Okay. And who qualifies for CAPI? Seems pretty broad. LPRs, refugees?
Right. LPRs, refugees, asylees, certain victims of trafficking or domestic violence. But it also covers this really critical and often confusing group,
Right.
people permanently residing in the U.S. under color of law. Prukalal.
Prukalal. Yeah, that term confuses everyone. What exactly is it? It's not like an official visa status, is it?
No, absolutely not. It's highly nuanced because PRUCL is not a formal immigration status that USCIS, Immigration Services recognizes. It's purely a public benefits eligibility category. It kind of grew out of administrative realities.
Okay, so what does it mean then, practically?
PRUCL describes individuals who the Department of Homeland Security, DHS, knows are here in the country, but the government isn't actively trying to deport them at that moment.
Like, they're on a list somewhere that says, hold off.
Kind of. Think of it like that. It could include people whose deportation has been formally canceled, or maybe someone who's applied for asylum or permanent residency and is just waiting for a decision. Certain people with temporary protected status might fall under it sometimes. It's basically a mechanism states can use, or allowed, to make sure people don't completely fall through the cracks while the feds are sorting out their long-term immigration case. It acknowledges reality without granting a formal status.
I got it. Acknowledges the bureaucratic lag and human need.
Mm.
Okay, that feels like a good spot to pivot. We've talked about who might get help. Now the flip side. Responsibility. What happens financially when someone does get LPR status, whether they need help or not? And you mentioned global obligations.
That is the crucial takeaway, yes. Getting that green card automatically makes you a U.S. tax resident. It's called the green card test. And this is fundamentally different from becoming a tax resident just based on how many days you physically spend in the U.S. each year, which is the substantial presence test.
Okay, green card test. So what does that mean day to day?
It means once you are an LPR, you are required by U.S. law to report and pay taxes on your worldwide income.
Worldwide.
Worldwide. It doesn't matter if you earned that income in your home country or working remotely for a company in Europe or right here in the U.S. If you're an LPR, all of it is potentially subject to U.S. tax law.
Wait a minute. So someone could get their green card, maybe live here a bit, then move back to their home country for most of the year, maybe run a business there, and the U.S. still wants tax filings on that foreign income.
Yes.
That sounds like a huge burden. Administratively, financially, how do people even find out about this when they get the card? Is it in the welcome packet?
It's a profound and often very surprising burden, especially for LPRs who might spend significant time outside the U.S., but the requirement is absolute. It continues until you formally, legally relinquish the green card through the proper process. And because the U.S. tax system cares about everything you earn globally, LPR status also triggers some mandatory foreign account reporting requirements.
Ah, right. This is where we get into those acronyms, FBAR and FATCA. People always mix these up. Let's try to keep them straight.
Absolutely, they are different. FBR first. That's FinCEN Form 114. Notice, FinCEN, not IRS. It's filed with the Treasury Department's Financial Crimes Enforcement Network.
Okay, Treasury, not IRS. And when do you file FBAR?
You must file FBR if the aggregate value of all your foreign financial accounts, bank accounts, brokerage accounts, maybe certain retirement funds, exceeds $10,000 at any point during the calendar year, even just for one day.
$10,000 total across all foreign accounts.
Yeah, correct. It's technically an anti-money laundering tool, but it applies to everyone with foreign accounts over the threshold, regardless of where the money came from. It's filed separately from your tax return, usually online by April 15th, though there are extensions.
Okay, FBAR, $10,000 threshold, Treasury debt, separate filing. Got it. Now, ESIA.
Right. FCA is the Foreign Account Tax Compliance Act. This one is filed with the IRS. It's Form 8938, Statement of Specified Foreign Financial Assets, and it gets attached to your annual tax return.
Okay, IRS, part of the tax return. What triggers a FESIA?
This form deals with specified foreign financial assets, which is broader than just accounts. The reporting thresholds are higher than FBAR, and they vary. It depends if you're filing single or married and whether you live inside or outside the U.S. But generally, for someone living in the U.S. filing single, it might kick in if your foreign assets exceed $50,000 on the last day of the year or $75,000 at any point during the year. Higher thresholds if you live abroad.
So higher thresholds, broader asset types, filed with the IRS. Both FBAR and FATCA sound like they require intense financial disclosure. And I bet the penalties for messing up are steep.
They can be incredibly severe, yes. Both civil and potentially criminal penalties for willful noncompliance. It's serious business.
Okay, so worldwide income reporting, FBAR, FATCA, it really feels like this setup could easily lead to people paying taxes twice on the same money. Like, if I earn income in my home country, I pay their taxes, then the U.S. taxes it too. How do LPRs avoid that double taxation nightmare?
Thankfully, there are mechanisms to prevent that, primarily the foreign tax credit.
Foreign tax credit, okay.
Or, less commonly, you might take a deduction for foreign taxes paid. But the credit is usually better. It allows you to offset your U.S. tax liability, dollar for dollar in many cases, by the amount of income tax you already paid to the foreign country on that same income.
So it reduces your U.S. tax bill.
Exactly. But it's complex. You have to use specific IRS forms, like Form 1116. And sometimes you need to rely on bilateral tax treaties the U.S. has with other countries. Claiming treaty benefits often requires another specific form, like Form 8833. Careful planning and filing are crucial.
Man, it just keeps getting more complicated. And as if all that wasn't enough compliance headache, there's one final potential financial hurdle if someone decides they want to give up their green card. The exit tax.
Yes, the exit tax. It can be a very significant closing chapter for some LPRs. It applies specifically to long-term residents.
Long-term meaning?
Meaning you held LPR status, you had the green card for at least 8 out of the last 15 tax years.
8 of the last 15, okay.
If you meet that definition and you decide to formally relinquish your green card, you have to be extremely careful. If you also meet certain high financial thresholds.
Like being pretty wealthy.
Exactly, like having a net worth over $2 million, or having had a high average annual income tax liability over the previous 5 years. If you meet those thresholds, the U.S. government essentially treats you as if you sold all your worldwide assets at fair market value on the day before you expatriated.
Wow, a deemed sale.
Yeah.
So you pay capital gains tax even if you didn't actually sell anything.
Precisely. It can trigger huge capital gains taxes. You get designated a covered expatriate. It's designed, to prevent wealthy individuals from just walking away from U.S. tax obligations by giving up their status. But it means anyone considering giving up their green card after 8 years needs meticulous tax planning beforehand.
That puts an incredible weight on being an LPR. It's not just filing correctly, but this ongoing, potentially global financial entanglement tied to the status itself.
Yeah.
Okay. We've hit benefits eligibility and the heavy tax responsibilities. Let's shift to the workplace now. This area presents a really striking paradox, doesn't it? Especially for undocumented workers who are often in the most vulnerable jobs.
It really is a paradox.
Yeah.
Because on paper, at least, federal and most state labor laws are what we call status blind.
Status blind, meaning the law protects everyone, regardless of immigration status.
Generally, yes. Undocumented workers enjoy nearly all the same basic labor rights as documented workers. This is legally established. The idea is to prevent unscrupulous employers from undercutting wages and safety standards by hiring vulnerable workers they can exploit. That would hurt all workers.
Okay, so give us the list. What are the really critical bedrock labor standards that apply to basically every worker on U.S. soil?
All right. They're entitled to minimum wage, federal minimum wage, state minimum wage if it's higher, overtime paid time and a half after 40 hours usually, required meal and rest breaks under state laws like California's, and critically, they're generally eligible for workers' compensation insurance if they get injured on the job. The injury happened at work, the coverage applies.
Okay, wages, hours, breaks, workers' comp. What about discrimination?
Yes, anti-discrimination laws also generally apply. They're protected against discrimination based on race, gender, religion, etc. under civil rights laws. Basically, the legal principle is, if the job exists, the rights attached to that job exist for whoever is doing it.
But, and this is a huge but, the reality on the ground can be totally different because of the risk of retaliation.
Yeah.
Right. An employer can just threaten to call ICE.
That is the absolute critical distinction. The rights exist on paper, but enforcing them is the challenge. If an undocumented worker files a legitimate wage claim for unpaid overtime or complains about unsafe working conditions or reports harassment, there's a very serious real risk that the employer will illegally retaliate by threatening to report them or actually reporting them to immigration authorities. It's used as blackmail, essentially, to silence workers.
The rights are there, but fear prevents people from using them. Now, to try and counter this, we saw the introduction of something called DALE E, Deferred Action for Labor Enforcement. How effective is that? Does it actually create a safe space for workers to report abuses?
DALE is an attempt, a relatively new tool, to create a kind of shield. If a worker is involved in a labor dispute, like they're cooperating with the Department of Labor or the National Labor Relations Board investigation, they can request DALE. If granted by DHS, it offers temporary deferred action. That's basically a commitment from DHS not to deport that specific worker for a set period, usually 2 years now, I believe, and it's potentially renewable.
2 years of protection from deportation. Does it let them work legally too?
Yes. Crucially, getting DALE allows the worker to then apply for an employment authorization document, a work permit, so they can work legally while the labor case proceeds. It's a vital administrative tool intended to help agencies enforce labor laws by protecting witnesses. But it's really important for people to understand DALE is temporary. It does not provide a path to a green card or permanent status. It's a temporary shield for a specific purpose.
Okay, a temporary shield. Got it. Let's pivot slightly within the workplace topic. State-level income replacement programs. Let's use California again, since it comes up a lot in the sources. If an undocumented worker is paying taxes, contributing, how are they treated when they need temporary income support, like if they lose their job or get sick?
This is where that status plan idea breaks down quite a bit, and the specific program matters. For unemployment insurance, UI undocumented workers are typically ineligible.
Why not, if they were working and paying into the system?
Because a key requirement for UI benefits is that you must be ready, willing, and able to work legally. State agencies generally determine that undocumented workers lacking work authorization are not legally available for work, so no UI.
Okay, no UI. But what about programs funded directly by employee paycheck deductions, not employer taxes?
That's where it often shifts. Take California's state disability insurance, SDI, and paid family leave, PFL. These programs are funded almost entirely by mandatory deductions from employee paychecks.
Right, you see it on your pay stub.
Exactly. Since the workers themselves have paid into these specific funds, California generally considers them eligible for SDI benefits if they have a non-work-related illness or injury, or PFL benefits to bond with a new child, or care for a sick family member, regardless of their immigration status.
So if you paid in, you can get it out for SDI and PFL.
That's the general principle there, yes. And for context, this is increasingly significant because the benefit amounts for SDI and PFL in California are set to increase substantially starting January 1st, 2025. They'll replace a much higher percentage of regular income, like 70 to 90% for lower wage workers.
Okay, and all of this working, paying into SDI PFL, even if ineligible for UI, underscores a really crucial point you made earlier. Every worker, regardless of status, has tax obligations, right?
Absolutely. Everyone who earns income in the U.S. is required by law to report that income to the IRS.
How do they do that if they don't have a Social Security number?
They use an individual taxpayer identification number, an ITA. You apply for an ITN from the IRS specifically for tax reporting purposes if you have U.S. income but aren't eligible for a Social Security number. And the financial contribution from workers using ITNs is immense.
Yeah, the numbers we saw were pretty staggering.
They really are. Estimates suggest undocumented immigrants contribute something like $11.74 billion, maybe more now, every year to state and local economies just through the taxes they pay, income tax, sales tax, property tax. So they're fulfilling that financial responsibility, paying billions into the systems that fund schools, roads, public services, while, as we discussed, being barred from accessing most of the major federal and state safety net programs those same tax dollars support.
Wow, okay. That is incredibly dense, illuminating, and yeah, frankly, just a really complex set of rules we've walked through. We covered the three big pillars: the benefits maze, navigating who gets what, the global tax obligations that come with LPR status, and then the precarious balance of workplace rights versus the real risk of retaliation and how safety nets apply unevenly. The common thread through all of it seems to be immense administrative complexity and the need for constant diligence.
It really highlights these dual realities people face. What's fascinating and maybe a bit jarring is the balance individuals constantly have to strike. Think about it. On one hand, for federal tax compliance, especially if you're an LPR with foreign ties, you have to practice total transparency. You need to potentially disclose significant worldwide wealth and assets for things like FBAR and FATCA.
Right, prove your wealth for tax purposes.
Exactly. But then on the other hand, to qualify for essential state-level help like CPI, or maybe even just to get a fee waiver for an immigration application, you often have to prove the exact opposite: extremely low income, minimal assets, basically proving poverty.
It's like a constant push and pull. Prove you have money here, prove you have no money there. It must be exhausting. Thank you, really, for walking us through all this layered source material. It clarifies a lot.
Absolutely. And maybe just to leave you, the listener, with a final thought to chew on, something that really encapsulates this pressure. Consider the criteria USCIS uses when someone applies for a fee waiver for certain immigration forms, like the N-400 application for naturalization, citizenship. There are basically three ways to prove you can't afford the fee. One, show you receive a means-tested public benefit. Two, prove your household income is below 150% of the federal poverty guidelines. Or three, demonstrate some other kind of extreme financial hardship. Think about what that requires: deep, often intrusive financial disclosure, providing bank statements, proof of income, listing all your assets and debts, just for the chance to have the application fee waived. It shows how the system constantly requires individuals, especially those with fewer resources, to financially justify themselves, to prove their eligibility at almost every single step, whether they're trying to prove wealth to comply with tax law, or prove need to access a benefit, or even just file a form. It's a constant state of financial justification.